Barely a day goes by when the word rights is not deployed in the midst of some controversy. Left-wing lawyers invoke human rights to block the deportation of foreign criminals, while conservatives and classical liberals champion a natural right to free speech against the predations of government, big tech, and the pile-on campaigns of modern cancel culture. Nigel Biggar, Emeritus Regius Professor of Moral Theology at the University of Oxford, has gone to the trouble of thinking deeply about whether the concept of rights, so often taken for granted, actually makes philosophical sense. He joins me to discuss whether there is such a thing as a natural or a human right, and even if these are legitimate in some sense, have they been cynically weaponized against democracy, national traditions, and other important values? Nigel Biggar, thank you very much indeed for joining me. Rights talk saturates modern politics and discourse, and while people of different ideological persuasions will tend to assert different rights in given political context, so you have some people asserting the right of unborn children to life, and you have others on the other side of the debate asserting the right of the mother to terminate a pregnancy if she wishes. You stand in a long-standing tradition of skepticism about the very concept of rights altogether. What do you find are the most compelling aspects of that tradition?
So, Harrison, I first became interested in this question when I was writing my book on war, which was published under the title In Defense of War over 10 years ago. And that book was based on the long-standing Christian tradition of so-called just war reasoning about the rights and wrongs of war. And I noticed in this 1,600-year-long tradition, the concept of a right wasn't used at all. And that raises the question in my mind as to the two possibilities. One is the Christian tradition has missed a trick for 1,600 years, or the Christian tradition has an insight that contemporary discourse, which is rights saturated with talk about rights and with little attention to other moral categories such as duties or virtues. So that is the question as to quite what the place of the concept of a right in ethics really is. And that's what precipitated me to write this next book on what's wrong with rights. And it's got a question mark at the end of it, which was published 4 years ago. Because I wanted to assess just what place the concept of a right has in ethics and in legal discourse. The other reason was that there are some philosophers and some theologians, Catholic philosophers like Alistair MacIntyre and Ernest Fortin, Anglican theologians like John Donovan
And John
Milbank, who have expressed a strong skepticism of what some call modern rights. And I think I thought that they were onto something, but I wasn't quite sure where I wanted to go all the way with them, so I needed to assess that as well. So that's really what got me into this topic.
It might be worth entering a preliminary distinction here, which is very, very operative throughout your book, What's Wrong with Rights, namely the distinction between natural right considered in a kind of singular comprehensive sense,
Yep.
and natural rights considered as plural entities that certain people bear in given context. Because I think I understood part of your point in the book to be that since the plural sense of rights, how we talk about rights, natural rights, and indeed today human rights, are a kind of paradigmatically legal institution that presupposes the existence of social arrangements that are already in place that can enforce and uphold these rights and make them actionable in the real world rather than just dreamy abstractions. Go on.
Yes. So I try and avoid the term natural right because it's just confusing.
Okay. Yeah.
I prefer to refer to natural morality. I'm an ethicist. I'm a Christian ethicist. I do think there are universal moral principles, albeit differently reflected in different cultures. So I believe in natural morality. There are many people who assert natural rights, that's to say, rights that are the property of individuals, and these are fundamentally moral and also fundamental to morality. And certainly in the Catholic tradition, that's so. And in the course of my book, I ended up disagreeing with that. I want to say that the concept of a right as the property of individual is is a legal phenomenon. It depends on a set of social institutions. It's granted by a society, and there may well be strong natural moral justifications for the granting of a legal right. But I don't want to talk about natural rights. If you would ask me why, I would say for this reason, that some people say that wherever there is a profound human need, whatever is necessary for human existence, like water or food, wherever there's a profound human need, an existential need, there is a right, a human right. So, for example, in the recent, this is part of the reasoning behind the decision to issue arrest warrants for Benjamin Netanyahu. The idea that because Israeli Defense Forces in Gaza are conducting military operations which do deny sometimes civilians in Gaza access to water, that their natural human right to water has been violated, therefore the action of the IDF is illegal and immoral. I don't believe there is such a thing as a natural human right to water, because it all depends on whether there are resources and who is responsible for bringing them to the needy and whether they can bring them to the needy. So suppose you are dying of thirst and I have access to this pool of water here. No, well, suppose you're dying of thirst and I'm here, but there's no water for me to bring you. You can't have a right to something that doesn't exist. Or suppose you're dying of thirst and there is a quantity of water over there I could bring to you. It's just that I have responsibility to those people over there. I owe it to them. So I'm not obliged to bring it to you because I can't bring it to you both. I'm obliged to them. So whether or not you have a right to water depends on, A, whether it's possible to bring it to you, B, whether there's someone who is obliged to bring it to you. And there may be social institutions, international institutions that tell us who's responsible to bring what to whom. But until we have those institutions, there ain't no right.
It's interesting that you say that, because throughout the book you're constantly drawing on in some limited sense on the social contractarian tradition, and I say in a limited sense for a reason, because you're not a Hobbesian. You don't believe that the state of nature is this purely amoral place where there is nothing but desire after power, of power after power that ceaseth only in death. You haven't got that very grim view of human nature or view of natural morality that Hobbes has. He doesn't see it as existing, whereas you as a Christian are committed to the fact that even in the absence of social institutions, whether that's because it's virginal territory, whether that's because, as you mentioned the case of Israel, whether that's because war means that there are no agreed norms of warfare, and of course societies can break down as well. In those contexts, there are still certain ethical principles that should hold sway.
Yes.
Is it not the case, though, because one of the things that struck me throughout your book is that you were making a very strong case about how when we smuggle in the idea of rights, and you've just given the example there, we assume so much that cannot necessarily be assumed at the outset in terms of conditions, in terms of circumstances and pre-existing social institutions. But if those conditions are met in certain circumstances, and we believe in natural morality, you don't want to say natural right because it's confusing, but we believe in natural morality. If we were to change the word a right to, say, a moral immunity or to a moral entitlement under certain circumstances, would that be acceptable to you? In other words, is your problem more a linguistic one than a conceptual one?
It's more than just linguistic. So yes, okay. So in the absence of any social institutions, if you have the need for water, I have access to water, and I can bring it to you, I'm not obliged to bring it to anyone else, then you have a moral claim against me.
Yes.
But unfortunately, the force of your moral claim depends on my conscience. I may not have one.
Yes, yes.
So I think to say that you've got a right is too strong. You have a claim. It's only when there are the social institutions of law and police and courts that your moral claim acquires the force of a right, so that if my conscience fails me, there are other powers that can compel me to give you what you need. So the one reason I try and avoid talking about natural rights is that it too often implies a moral claim has a force that in the absence of effective social institutions, it actually lacks.
So, and necessarily translating these rights into specific laws is a difficult task. But if it is, so to speak, and this is why I'm wondering whether the problems are more linguistic than conceptual, if it is, so to speak, the right thing to do, then its rightness and therefore its status as a right precedes its passage into law. So are we not here talking more about the practicability of bringing this about rather than the strength of the ontological claim which is truly moral and can precede the existence of a civil society?
Harrison, there is yes, there is. I'm making a linguistic point, so I quite understand that if what you mean by natural right is a moral claim that should be met, and that there should be legal institutions, there should be social institutions that strengthen that moral claim, then you could talk about a natural right. I just think it's confusing because sometimes, for example, Helena Kennedy, with regard to Gaza, talks about a human right to water, a natural human right to water, and I say, well, no, it doesn't exist. So I just prefer to avoid the talk about not only about natural right, because I want to talk about natural morality. I'm not talking about a legal thing. It's natural morality. And I want to avoid talk about natural rights because I think in some cases it implies a degree of force and security of what is claimed that doesn't exist.
Yes, and that can only be guaranteed at scale by precisely the kinds of social arrangements, constitutional arrangements, and legal arrangements which the very people who invoke rights and as a kind of moralizing Trump claim often want to tear apart in the course of revolutionary projects. This is what you call in your book the British sceptical tradition.
Yes.
You name four thinkers in particular. Would you like to run through some of the concerns that those people have? Because none of them, as I recall, were in fact moral anti-realists. And for people who don't know what that means, none of them were completely amoral in terms of their understanding of whether there do exist proper ethical duties. There are genuine answers to moral questions. I think all of them are moral realists, and yet they're highly skeptical of rights talk in the British skeptical tradition.
Yes, you probably are closer to my text than I've been. It's 4 years ago since I wrote it, so but you can supplement what I remember. So in terms of the concerns of right skeptics, such as Edmund Burke, of course, such as Honora O'Neill,
Yes. David
Ritchie, and Jeremy Bentham, of course.
Yes.
Among their concerns would be certainly, in the case of Burke, thinking about the French Declaration of Rights, the abstraction of lists of rights, and I'm quite Burkean on this. The abstraction gives license because they are so abstract, they can be interpreted in so many ways, and in the case of the French Revolution, can license the most reckless destruction and violence. So that's one concern about the abstract nature of rights. And I think it applies, frankly, to all lists of rights or conventions of rights. We can come on to that later, because in the case of conventions or bills or lists of rights or charters of rights, it hands over to judges enormous room for arbitrary discretion.
Yes.
We come up to it later. So that was one concern of the skeptics. Another, which Nora O'Neill voices, is that it gives rise to completely unrealistic expectations.
Yes.
It's utopian, and she thinks we need to be rather more sober.
Particularly, if I may just interject there, one of her concerns, of course, because Nora O'Neill, who I believe is still alive, she certainly was writing recently. I forget the exact name of her book. We'll pop it up on the screen. But she's obviously writing in the aftermath of the kind of 1945 the obsession, post-war obsession with human rights, and many of the rights which are adumbrated in that document and in subsequent documents are, properly speaking, not negative, they're positive. Could you explain that distinction to people? Because it generates special problems that are not operative with negative rights, but are with positive rights.
Yeah, so generally speaking, so a negative right is a right to be free from something, free from interference. Well, generally speaking, it's possible for someone, it's very easy for anyone not to interfere with you, basically. Just you decide to do it.
It imposes a universal duty which can be upheld.
It can be upheld.
Yes.
Positive rights are rights to a benefit of some kind. Well, that all depends on whether resources are available.
Yes.
And that's positive rights in particular are contingent upon social and economic resources.
Mm-hmm.
So the thoughtless expansion of positive rights becomes utopian simply because, in fact, the resources don't exist.
Yes, and I think it's David Ritchie in his book on rights says it's an extraordinary gamble on providence or something else.
He says it very wryly about an extraordinary draft upon the Bank of Providence.
That's right. Yes.
This is with regard to an early American Bill of Rights. I think in one of the southern states.
Yeah, it was in Virginia.
Virginia, was it? Okay. Not only affirms a right to pursue happiness, but affirms the right to happiness. That's itself.
Precisely.
Yes. He makes a very wry comment on that.
One of the particularly interesting things about Honora O'Neill's book is that she actually collapses this distinction to some extent because. So with a positive right to water, we've mentioned the right to water, for example, that is so contingent upon the circumstances. Is there enough water? And all of a sudden, water isn't just conceived of as a natural good, which we would all accept that it is a natural good for human beings to pursue. But if it's a right and the water is not available, that somehow moralizes the situation in ways where people can claim that their right has been violated, whereas when in fact, in order for your right to be violated, it requires an agent. And if it's a natural phenomenon that the resource is not available. So this is the problem that you're talking about with positive rights. But even negative rights can be difficult to uphold and not necessarily to uphold because it makes a claim on certain people to forswear interfering with your life. Negative rights necessarily do. But let's say that someone does interfere with your right, and you are unable to resist them because circumstances aren't such that you can resist them, it still does require second-order enforcement in the form of courts, and that is a finite resource as well. But you need enough lawyers, you need enough judges, all that sort of thing.
Yeah, you're quite right. So the distinction is not a stark one. But what you were just saying now indicates another problem with the proliferation of rights, particularly proliferation of the rights by courts. Courts have no responsibility for providing the resources to enforce these things, and so the imprudent proliferation of rights imposes duties on a state usually, which in due course states will be simply unable to perform.
Yes.
So it burdens the state.
Yes.
Which is one good reason why in the whole court shouldn't make rights.
Yes, and we're going to get to that in due course. But in case people think that we're being too abstruse and abstract here, I mean there was a test case of this has been in Rwanda recently in the aftermath of the genocide, because most people would say if we're going to talk about positive rights and negative rights, the right not to be imprisoned is technically a negative right because people can refuse to imprison you, but you will usually then follow it without a fair trial. And then, unless we have the means and resources to stage a fair trial, as is not the case in a post-genocidal wasteland such as Rwanda was in the 90s and 2000s, you're trying to put all of these people on trial to tell people about some of the chaos that generates.
So I do think there are things against which and to which all societies should grant their citizens legal rights. And one of those would be to a fair trial. I mean, who can possibly disagree with that? So indeed, after the 1994 genocide in which 800,000 Tutsis were killed by Hutu, there were about 100, I think at the end of the 90s, there were about 120,000 people accused of genocidal crimes in Rwandan prisons. These prisons were built for 12,000 people. Unsurprisingly, many of the inmates were dying. But the cost of putting each of these 120,000 inmates through the kind of trial that we in the West are accustomed to would have been very expensive. And at one point, I remember someone reckoned that at the current rate, it would have taken 200 years to process them. So what happened was that the Rwandan government decided to distinguish two kinds of cases. One would be for the major instigators or organizers of the genocide. They would be trialed by the International Tribunal according to the fully developed Western processes. Others accused of genocidal crimes would be tried in gacaca courts, which were village or community fora, and in those cases, because most lawyers and judges had either fled the country or been slaughtered, and because no international body was going to supply judges, there were not sufficient lawyers around to provide legal counsel for the accused. And so these gacaca courts did not provide legal counsel to the accused. They had other ways of trying to ensure fairness. So a conviction had to be unanimous among 9 judges, I believe. The idea was that if there was false testimony, it would be called out because it was a local court. People knew what happened in the locality. And I think there was some kind of a right to appeal. But so in terms of securing the fairness, it was weaker than we were used to.
Yes.
But there's a reason for that. And given the resources available, nothing better could be done. That didn't stop Western human rights organizations like Human Rights Watch in New York and Amnesty International for berating the Rwandan government for not providing a fair trial according to Western standards and what they called a human right to a fair trial, which means a right to a fair trial according to norms in the West.
Yes.
And that kind of boneheadedness on the part of rights advocates seems to me to be, in the long term, counterproductive, because in the case of the Rwandan government, after a certain point, this just stopped listening because they thought these guys in New York do not understand our circumstances, nor do they care to try. So why should we listen to them? So the long-term effect of that actually is to discredit rights talk because it is so imprudent. It is so absolutist and fails to acknowledge how, if not the right itself, I mean, I think a right to a fair trial should be universally granted.
Yes.
But the form of the right and the degree of fairness that's guaranteed has to vary according to circumstance, and the rights advocates wouldn't recognise that.
Yes, and so even though on a surface analysis, not surface analysis, but on a kind of preliminary analysis, there is a conceptual distinction worth drawing between a positive right, namely a kind of an entitlement to something, and what were legally inscribed, and a negative right, namely a rightful immunity against something. Yeah. In the long run, in the second case, the immunity against imprisonment without fair trial. Later down the line, it's not a complete resource-free exercise. It still nevertheless require legal institutions to be in place. Another claim that is often made, and it's been made as well as by some of the Catholic theorists that you were talking about earlier, people like Alistair MacIntyre and already Anglo-Catholic ones, I think he describes himself, like John Milbank.
Yep.
There's a concern on the part of Christians that rights, though important, whether considered legally and considered naturally, because many Catholics actually do affirm the existence of natural rights, like John Finnis, for example, nevertheless, it does monopolize the rest of moral discourse. And this is a concern that you share as well. There's very little place often in modern rights talk for concepts like duty and concepts like virtue. Would you like to elaborate on that concern?
No, I will do. Just before that, it strikes me as something we missed, because a common criticism of modern rights by the likes of MacIntyre and others is that they are radically individualist, Hobbesian, and therefore corrosive of the social good. So they're only concerned with the wishes or claims of individuals with no recognition of the common good. I decided that's not true for two reasons. One is, of course, if a right is granted to you, then I have a duty. So it is social. it governs our relationship. So it's not simply corrosive of social bonds. The other reason I discovered it reading Mary Wollstonecraft, the early feminist philosopher writing in the late 1700s, writing about the rights of women. And she had a very interesting argument, which I thought was plausible, namely that in her time, women had no political rights. So she said, what happens is that women seek power by other means, by sexual enticement, by flaunting their sex, by emotional manipulation. And the result is that relations between the sexes are corrupted by this as it were, subterfuge. And so she argued that granting women political rights would liberate them from those kind of tactics and make relationships more healthy between the sexes. Actually, I thought it was a rather good argument.
And thereby thickening the social fabric.
Exactly.
Through rights rather than against rights.
Exactly. So,
yes.
That's right. So I don't buy the idea that legal rights are necessarily corrosive of the social fabric.
And as to monopolizing all other forms of moral discourse.
Yes, indeed. So let me give an example. It's, in my experience, quite unpopular example. So I'll give the example, then I'll rescue the main point, just in case you and others protest against the example. So the example I give is 2015. A couple of Islamists walk into the office of Charlie Hebdo, the French satirical magazine in Paris, and shoot dead, I think, 11 of the staff, including the editor, which was atrocious. And in the aftermath, of course, there were widespread protests in the streets of all our major cities, protesting against these killings and in favor of free speech. And I entirely supported the protests against the killings. But I did think to myself, along these lines, yes, Charlie Hebdo had the legal right to, I should have explained, the reason the Islamists were upset was that Charlie Hebdo had published cartoons of the Prophet Muhammad, one of which had a bomb under his turban, which made a certain point. So Charlie Hebdo certainly had the legal right to print cartoons mocking the Prophet Muhammad. But I thought to myself, okay, so what was the purpose of that? Well, Muslims, faithful Muslims, I don't suppose read Charlie Hebdo much because it's a secularist, satirical magazine which delights in provoking religious people, among other things. And so this was designed to amuse French secularists by mocking religion. And I thought to myself, well, you could do that. It's just that in terms of helping aiding communication between French people and French Muslims, it doesn't help to spit in their sacred cows just for the fun of it. Mm-hmm. So I thought to myself, no, I mean, Charlie Hebdo had the right to do that. Legally, morally, I say not. The main part out of this is we have a legal right, which is one thing, but our use or our use of the legal right is subject to moral obligations. So that I could sit here and insult you and provoke you and misrepresent you, Harrison, without breaking the law, but I'm morally bound not to abuse my legal right to do that. And what is I made this point in an article I wrote. I was aware at the time, and I had not heard anyone mention it since. I've never heard anyone make that point. Mm. Now, just back to Charlie Hebdo, I understand why people object to that, because satire is sometimes a good thing, and maybe the logic of my argument ends up saying, well, all satire is wrong. But I think the general point is this, that we ought not to spit in other people's sacred cows just because it amuses us. We have a moral obligation not to. But the focus on rights talk obscures
yes.
the the issue of moral duties that may supervene upon our use of the right.
Yes.
The other thing that obscures is virtue talk. That
Can I just interject one thing?
Yes.
Just one very tiny thing.
Yes.
Even if it's true that satire performs a public good, it still is in service of the larger point, which is that there are kind of moral concerns beyond mere rights talk. If you're saying that in addition to the Charlie Hebdo lot having a legal right to perform in a certain way, if you're adding onto that, tagging onto that, and they were right to do so, you're still appealing to forms of moral good that rights on their own don't get you.
No, okay. So you have to appeal to some kind of moral intuition
Yes.
in order to justify this use of that right. Good. So the other thing that rights talk tends to put off the table, not just moral duties, but also moral virtues. And we have all sorts of rights, which we can abuse. And what we need, therefore, is a citizenry who have the virtues, the moral qualities of character that enable them to use rights well rather than badly, such as self-restraint, or in this case, charity, or truthfulness. I mean, I think we should always aim to speak the truth. We should never aim to offend. But if a truth is sufficiently important to be spoken, one should speak it at the risk of offending. But offense is not the point. Yes. Offense is a side effect.
Yes.
But you know, we need certain virtues to help us control ourselves and to use rights well. And if we don't have the virtues, we don't use the rights well, then we risk bringing the right into disrepute and discredit.
Yes, and I don't think this point has ever been more cultishly made than it was by Burke himself in Reflections on the Revolution in France, where he says, in order for society to exist properly, a check on appetite needs to be imposed from somewhere, and the less that it is imposed from within through the cultivation of virtue, the more that it needs to be imposed from without. I think he says at one point, men of intemperate minds can never be free, their passions forge their fetters. And so virtue... virtue ethics isn't only an important supplement to rights talk, it's actually a crucial underpinning for rights talk to be feasible in the long run as well.
Can you just observe that in this discussion of rights, recourse to banking metaphors has appeared twice. Once in the case of virtue, once in Burke.
Yes, it has. Yes, so I will let the viewers conclude what they might want to from that. We should say as well that a particular concern today is that obviously we now live post the 19th century in mass democracies that are supposed to have democratic processes, and there's a tension between talk, particularly of human rights, and often recourse is made to judges rather than elected politicians in order to uphold these in practice. And another crucial point for democratic politics to work is that we don't know where we're going to end up. It's a deliberative process. And if you're starting with morally absolute claims, this is what John Finnis complains about in natural law and natural rights. Rights have this sort of conclusory force, as he puts it. They can just shut down the conversation in advance. That we've already got the answer. There's a kind of moral dogmatism and fundamentalism to it, which gets in the way and precludes the conversations that are supposed to be a characteristic of democratic politics. Could you talk a little bit about the tensions you find between rights talk, so pervasive in our democratic societies today, and their status as democratic societies?
Yes. So, I mean, Phyllis is correct. I mean, so much rights talk begins with an absolutist assertion of a right, whereas, particularly if of assent, the form of a right. I mean, as I say, some things should be guaranteed by means of granting a right. Lots of things to which we do have rights are discretionary. If we can afford them, we should have them, but not everyone can afford them. But in most cases, whether we have a right, or what form they should take, or how strong their guarantee should be, depends on circumstances. So we have to deliberate about these things before we conclude there should be a right, whereas so much rights talk begins with an assertion.
Yes.
It cuts off the necessary discussion about what prudent form this right should take. The other problem the problem with rights and democracy emerges when courts and judges are in the process of making rights. Mm-hmm. And this has become increasingly a problem, certainly in this country, thanks to the European Convention of Human Rights and our own Human Rights Act, but in other countries like Canada, which have their Charter of Rights and Freedoms. So again, we're talking about lists of abstract rights. Mm. And because the rights are abstract, judges in courts have enormous room to decide what this amounts to in practice. So taking Canada in 2015, the Supreme Court of Canada, appealing in part to an unspecified right to liberty that appears in the Canadian Charter, decided that the Canadian Federal Parliament was in contravention of the Charter of Rights and Freedoms in not granting a right to assisted suicide. In spite of the fact that the Canadian Parliament had discussed this repeatedly over years, I think as recent as 2010, it had decided again not to grant such a right. But the court, as it were, trumped Parliament. And in so doing, it made a judgment about what a common objection to granting a right to assisted suicide is that in practice it will expose vulnerable groups to pressure to choose this right. And the court, the handful of judges, or was it a judge, in their own best wisdom, decided that the risk wasn't high. Point is this: that wasn't they weren't, as it were, exercising their legal skills. They were making a prudential decision about the likely effects, on which they have no special authority. And Parliament's a much better position to debate those questions, and Parliaments can set up commissions to commission an inquiry to look at to assess the likely effects. And the other thing about courts is that they have no responsibility for dealing with the effects.
You know.
And the issue of whether to grant a right to suicide is highly controversial. It has divided societies.
It's being debated in this country now.
Absolutely, and it divides us. One feature of a court decision, unlike a parliamentary decision, it can't be reversed. Mm-hmm. So if in this country the Supreme Court were to declare that it thinks that Parliament is in contravention of the ECHR in not granting such a right, I would feel disenfranchised. I also find myself being to talk about judicial tyranny.
Yes. Certainly judicial, like oligarchy, which is a phrase you use in your book.
Yes. So I think the general point is this: lists of abstract rights give judges the responsibility and the power to make law that a democratically elected body has not made, and it seems to me that they are overreaching themselves.
Yes.
And abusing their privilege.
And it's interesting because this is a problem which enters into rights talk even after all of the legal architecture that we've been talking about. It's a problem when that's not in place. But even when it is in place, it can still generate problems if it's undermining other important values you have in your society, like the importance of deliberative processes in making a democracy function, making people feel as though there are the proper lines of accountability between rule and rulers. If the rulers are unaccountable and don't even really need to survey the effects of certain consequential decisions they make, then all of that's undermined, even if you have got a very sophisticated and complex legal framework.
No, indeed.
In place. I don't want to get too partisan about this or too sort of ideologically zealous about it, because there have been times in the past, and you actually mention one in your book, when rights talk has been the preserve of people with more small c conservative concerns. And so I think didn't it enter into canon law in the 14th century because the Pope was keen to uphold the right to private property, which these kind of socially radically Franciscans were questioning. And so there are contexts in which rights talk serves what we might say is a conservative coded agenda. But I think it's fair to say at the moment that it is the beneficiaries of this kind of what Suella Braverman, the former Home Secretary in this country, has called human rights radicalism. It's much more a fashion among people who call themselves progressive, and it's a way of bypassing public opinion, which is often intuitively very conservative, in order to get otherwise very contentious and controversial stuff on the statute books, effectively, by the kind of judicial fiat of treating judges as a kind of unofficial legislature.
Yeah, so just to repeat, there's nothing wrong with legal rights, and much when I was looking into discussion about the origin of rights talk, what was it? Was it in the early medieval period?
Period on the 22nd or something,
or as some say, was it Thomas Hobbes and whatever?
Yeah.
Part of the problem about discussion is no one distinguishes clearly between an intellectual right and a legal right. But just to be clear, I think when you're talking about the property there, that presumably would be a legal right.
Yes.
Nothing wrong with that at all. In fact, the legal rights are quite important.
Yes.
But in current discourse, there's an imbalance in terms of rights talk appears to be the only kind of moral talk we have, and that. Yes, I mean the inflation of rights talk through the assertion of human rights to water or whatever that just don't make sense because they assume ample resource and they assume that somebody must be responsible for meeting it.
The reason I mentioned the controversies over property rights in the 14th century was because I wanted to make it clear that I wasn't being too partisan by saying that only left-wing people invoke rights in order to pursue what would otherwise be unpopular politics. That's the only reason that I mentioned it. You can be trying to conserve by talking about rights as well as being trying to disrupt by by talking about rights. I'm just one thing that does strike me as interesting, and maybe you don't have any theories about. Is why is it the case that almost always at the moment rights are generally invoked, or human rights are generally invoked as a kind of Trojan horse for pursuing otherwise very unpopular, democratically speaking at least, left-wing forms of left-wing politics?
That's a good point. I mean, I imagine, this is speculating on the hoof here, I imagine it's because the extension of the empire of rights is a means of extending the empire of progressive politics. And certainly, I mean, I discussed this in relation to a European Court of Human Rights case where certainly some of the judges, one of the judges, gave expression to a view that the more rights, the better, and the more the jurisdiction of rights, the better. There's a kind of utopian project here to cover the world in rights, and the more, the better. And at one point, I can't go into the details of the case, but he said, regardless of the facts on the ground, regardless of the facts,
yes,
we're in business of expending rights. And I just thought it's crazy. Yeah, but I think I talked about a kind of rights. I said talked about a rights fundamentalism, but also a kind of rights evangelism.
Yeah,
and so there's a notion. It's a notion. It's a noble notion, I suppose, that if you can control the world through law and rights, then you abolish conflict.
Yes.
First response is good luck with that.
Yes, I must say your answer is probably the true one, and that there's a kind of utopian cast of mind to it, which more naturally goes with secular progressive views of the world than it does with more kind of sturdy, small c conservative views of the world.
I go further. I say that a utopian cast of mind defines, a revolutionary cast of mind defines the left, and a reaction to that defines conservative. I mean, Burke.
Yes.
Burke is he's not against change or reform, but it's got to be gradual.
Yes,
and it's got to be realistic. Whereas progressivism is utopian and unrealistic.
Yes, and
and as Burke pointed out in his reaction to the French Revolution, utopianism sounds wrong but innocent, but actually it can be deeply destructive.
Yes.
Because it's so impatient.
Yes, and there's also a definite messianic quality to Wright's talk as well. You were touching on this earlier, and it's a very important dimension in your book as well. There's this idea that kind of we're going to delegate matters of conscience in pursuit of the ultimate good to legal processes or a legal regimen of human rights, which is supervised and overseen by these sorts of high priests belonging to a kind of judicial oligarchy. And one of the things that I found so interesting about your book is that while the motives for that, as you say, can be noble and properly speaking Christian, whether we're talking Christian or post-Christian, if they're not actual Christians, they might be humanists. It is actually, in terms of its comprehensive view of the world, actually very un-Christian, because there's a denial of human fragility there. There's a denial of human fallibilism. There's a denial of tragedy. You talk about how there is a kind of anti-tragic drive to the pursuit, to the project of covering the world in rights. Could you speak a bit about that?
Yes, I suppose
tragedy comes up quite a bit in the book.
I didn't know. I didn't know. I'm certainly aware that the concept of the tragic is one I use a lot, and I suppose it does relate to my sensitivity to not just human fallibility but limits. And we've talked about limits already in terms of limited resources.
Yes.
So back to the scenario where you are dying of thirst and there ain't no water, or there is water, I may not provide it. You're dying of thirst is terrible, and it's tragic.
Yes.
But the fact of the matter is there's no resource or there's no obligation. And that's what... so back to Gaza, Helena Kennedy and others tell us that the Israeli Defense Force has violated the human right to water. And I say, well, there is no human right to water. It is tragic that the pursuit of legitimate military objectives, namely the disabling of Hamas, has to involve risk to the lives of large numbers of civilians. Tragic. Part of the tragedy, of course, is caused by Hamas, which has chosen to hide itself in a densely urban environment, has chosen to build tunnels for military purposes, but not to protect civilians. No one talks about Hamas's responsibility. And I mean, the waging of war is always tragic because it is necessarily destructive, and even the waging of a war that is overall morally justified will involve elements of wrongdoing.
Yes.
So there was it really irritates me actually the kind of I talked about the imprudence of many rights lawyers, but there's also a complete neglect of human limitations, human fallibility, and therefore the law they promote is imprudent and reckless and counterproductive.
And strangely lacking in compassion and sympathy as well for the people who find themselves on the ground contending with these limits rather than just theorizing in an armchair.
Yeah. No, I mean, to be quite fair, and I mentioned this in one of the chapters of my book, I discuss a European court case to do with events in Iraq. And I noticed how before the case reached the European court, British judges had judged the case, and some of the judges clearly been reading history, military history, and they recognized that whereas it might make sense to grant a certain right to a certain kind of investigation of a death in Birmingham or Berlin, to grant it in Basra in 2006, when the British Army was just being overwhelmed by insurgents and rioters, when, as it were, the state was about to collapse, was insane. Nevertheless, the European Court overrode them and granted it. But some judges, judges can be well-informed and they can be prudent, but they need to read history as well as law books.
Speaking about, acknowledging the importance of limits in human affairs, sometimes you can't afford to make the best the enemy of the good. And another thing that we've seen with this kind of inflationary understanding of rights talk is a real. We've seen governments who want to control their borders and who want to exercise that right to control their borders, that collective right to control their borders, assuming they do, assuming there's not some kind of conspiracy or whatever, but assuming they do actually want to, in good faith, prevent illegal immigration from taking place. Into Britain, we've got these small boats coming across the English Channel every day, particularly in summer. It's becoming a very unsustainable, very expensive situation in Britain. I believe we spend about $3 billion a year putting up illegal immigrants in hotels. It's intolerable in democratic terms, and there's a sense in which the government is immobilized by human rights law from deporting these people in the proper fashion and not landing them, not throwing them into the jaws of a war in Syria, but or endangering them in any other way, but just not pursuing the perfect strategy for them. Yeah. So it's operative in those sorts of day-to-day concerns as well, isn't it?
Yeah. So for example, the last government, the Sunak government, had this scheme for diverting illegal migrants to Rwanda. So the idea was to make clear that any illegal migrant arriving in Britain, were they to be detained, they would be denied any possibility of residing in this country. And the idea there was to deter people from trying by saying, if you land here and you're rescued in the sea or arrested on the beach, you have lost all right to come to this country. What we're going to do is we're going to send you to Rwanda, and we'll process you there. And should you be deemed deserving of asylum, then you will be able to reside in Rwanda. Now, this provoked howls of protest from various quarters that somehow, yes, we were outsourcing, the British government was outsourcing its responsibility. And I thought to myself, well no, our responsibility is to make sure that genuine asylum seekers are given asylum. We're not bound to give them asylum here. So if Rwanda is sufficiently safe, and I thought it was sufficiently safe because even some UN body had been using it to deposit migrants, at least temporarily. If Rwanda's sufficiently safe, then that is all that's required. But there was some sense that not to give migrants, as it were, the optimal form of asylum rather than sufficient form was not acceptable, and I disagree with that. Particularly, the intention was to deter illegal migration by making clear that no one who attempts that and is found to attempt it will get what they want, and that should be a deterrent. But that wasn't permitted by critics on the left.
Last of all, speaking of whether we're speaking about natural rights or whether we're speaking about human rights, and another oddity that I've been struggling to wrap my head around is that rights strike me as a quintessentially metaphysical concept, not a scientific one. It's not something that you can find under a microscope. It doesn't come at the end of a painstaking experimental process. These are kind of metaphysical affirmations that people make, and on good faith will assume that they believe in them. Yet in our modern, very materialistic age, it's striking that metaphysical concept doesn't receive as much mockery as things like the virgin birth does, or as things like transubstantiation does. There's a kind of magical thinking that infuses it, particularly if they're materialists. As most human rights lawyers, most people, it's a very kind of secular project. It's not a particularly religious one. And there have been secularists, and the logical positives come to mind, people like A.J. Ayer, who writes in Language, Truth and Logic that because only scientific and mathematical statements are positively verifiable, everything else is meaningless, and he throws a lot of metaphysical talk into the dustbin on that account. And so he kind of accepts the logical consequences of his embrace of materialism and of his embrace of scientism. But a lot of people are not consistent on this at all. How do we account for the stridency with which nominally secular people hold to what is fundamentally a religious belief? And do you think that they're in some sense trading on axioms and premises and assumptions that their own actual metaphysical view of the world completely denies?
Yeah, that's a very good observation, Harrison, because certainly morality is not visible.
Yes.
If it's a force, it's an invisible, if you like, spiritual force. and human rights are supposed to be moral claims that are attached to human beings as human beings. The human being generates certain moral claims. Well, again, that's not an actual scientific assertion. It's a metaphysical one, a moral metaphysical one. And you're right. We on the whole we don't talk about metaphysical or we regard metaphysical things, or we regard moral talk as private, not public.
Yes.
And we become increasingly of the view that morality is a private affair, so we don't talk about behavior being immoral, we talk about it being inappropriate. And I think one reason why we are busy making so many laws and expanding rights is we want law and rights to do the job of morality, because it takes responsibility, takes away personal responsibility. So there's a kind of displacement here, and therefore, yes, the project to expand the kingdom of rights, it is a quasi-religious project, which is why people are so not committed to it, but so dogmatic about it. And I know I really was struck when my book began to get reviews, how lawyers were so defensive. So I had to point out that in one review, the lawyer reviewer hadn't noticed the title of my book as a question mark at the end of it, and he complained that I only gave rights 2 cheers.
Yeah.
And I thought to myself, good Lord! I mean, the shelves of libraries and bookstores are weighed down with books vaunting this right and that right and those rights. Can we not afford a few ones that ask skeptical questions? But the legal community, and Brenda Hale wrote a former president.
Is this Baroness Hale?
Yes.
Yes, yeah.
Sorry, it's Baroness Hale. Former president of our Supreme Court in the UK wrote a very unhappy review of my book in Prospect magazine. I thought, why are these lawyers so defensive? And she, she was particularly. She responded particularly to my criticism of a judgment of the European Court, and she said in the review, well, this was just a kind of one-off error. And Prospect gave me a right of reply, and I said, well, I'm glad she admits it was an error. But I went on to give an explanation as to why. And about that, she showed no curiosity. So I just found the lawyers who responded to my book defensive, unwilling to be provoked to think. And that really, really has surprised me. So there's a kind of dogmatic, maybe even rather insecure resistance to absorbing criticism, which I think that does it gives the rights project a religious quality in a bad sense. I mean, I am myself religious. There can be good senses, but insofar as being religious means being dogmatic and closed to rethinking and not allowing your article of faith to be questioned in any form at all, I think that's really unhelpful.
Rumors of the death of theology may have been greatly exaggerated.
Yes. This is theology in disguise.
Nigel Biggar, thank you for joining me.
Thank you very much.